Welcome to the 340B Hospital Updates webinar presented by NCHA Strategic Partners and Jeff Davis. My name is Jody Fleming, President of NCHA Strategic Partners, your shared services division of the North Carolina Healthcare Association. NCHA Strategic Partners would like to thank our business partner, SunRx, who introduced us to Jeff Davis. SunRx provides 340B management services to support NCHA member hospitals. So a little bit about today's speaker. Today's speaker is Jeff Davis, who advises healthcare organizations on Medicare and Medicaid billing and reimbursement issues with a special focus on the federal 340B drug pricing program. Jeff forged his deep knowledge of the 340B program and other Medicare and Medicaid reimbursement issues while working in the federal public policy arena. He spent more than 7 years working as Vice President and Legislative and Policy Counsel for 340B Health, an association of more than 1,400 hospitals and health systems participating in the 340B program. He draws on his experience to advise hospitals, pharmacies, other provider organizations, and vendors on 340B issues, including enrollment, contracting, audits, compliance, and self-disclosures. So without further ado, I would like to turn it over to Jeff Davis. Thank you, Jeff.
Well, thanks so much, Jody, and thank you much for having me today. I'm happy to be here as a sort of a guest speaker to share some updates for hospitals on the latest developments in the 340B drug pricing program. And there is certainly a lot going on 340B, and we could spend more than 1 hour talking about all latest developments, but we only have 1 hour today. So I tried to pick some of the topics that I think might be top of mind for hospitals right now. And these are 4 that I'm hoping we can get through during today's presentation. I'm going to start off talking about some eligibility issues related to the COVID-19 pandemic and some potential relief that might help some hospitals otherwise could be in danger of losing their PHRMA eligibility. We'll talk, of course, about the manufacturer policies that have been implemented over the last few years, restricting access to 340B pricing through contract pharmacies. And we'll talk about some of the changes in the HRSA audit process and specifically some of the changes with respect to the definition of a 340 eligible patient and diversion findings. And lastly, we'll just give a quick update on where things stand with Medicare payments to 340B hospitals and changes that we're expecting in light of the recent Supreme Court decision, which was really a victory for 340B hospitals. So we'll see how much of this we get through today. And I'll start off with an update on some of the latest issues related to eligibility. Just as a quick refresher, as I'm sure many of you know as participants in the 340B program, all hospitals, with the exception of critical access hospitals, in order to participate in the 340B program, must maintain a minimum DISH adjustment percentage. And the DISH adjustment percentage is really a tool used for Medicare purposes for those hospitals paid under the inpatient prospective payment system, Medicare. They're eligible for payments, DISH payments, in recognition of their high volume of care to low-income patients and compensated care. And that DISH adjustment percentage, which essentially dictates the amount of the DISH payment that a hospital might receive, is a tool that has been borrowed for purposes of the 340B program to evaluate whether the hospital serves enough low-income patients in order to qualify for the program. And different types of hospitals have a different minimum DISH adjustment percentage threshold that they need to maintain to participate in 340B. As I mentioned, critical access hospitals do not have a DISH adjustment percentage requirement, so this is not an issue for them. But for all the other hospital types, they need to maintain a minimum percentage. For hospitals that are participating as DISH hospitals, as well as freestanding children's cancer hospitals, they need to maintain minimum DISH adjustment percentage greater than 11.5%. And there's a slightly lower threshold for hospitals that have a Medicare designation as a rural referral center or a sole community hospital, they can qualify for 340B if they have a adjustment percentage that's greater to or equal to 8%. So just a little bit of background on the DISH percentage and what this really reflects, and then we talk about why there have been some challenges of late in light of the COVID pandemic meeting this DISH adjustment percentage threshold. But the DISH adjustment percentage is actually based on a DISH patient percent, the DPP, which is a measure of care in the inpatient setting to low-income patients. It's in a combination of patients that are qualified for Medicare and Medicaid, as well as a look at patients who qualify for supplemental security income, SSI, so essentially low-income Medicare patients. So there's really two different ratios that are combined together to form this DPP, and it's looking at your care provided to dual eligible patients and Medicare SI patients, low-income Medicare patients, as a percentage of either total Medicare days or total patient days. And again, this is only in the inpatient setting. So why does this matter? Well, when we talk about the COVID-19 pandemic, there have obviously, I don't need to tell you, been significant impacts on hospital operations as a result of the pandemic. And these operational impacts have had an impact on hospital DISH adjustment percentage. So you can see this in a number of different ways. So first of all, at the very beginning of the pandemic, March, April 2020, things were shut down. We had cancellations of elective procedures. Beds were either empty because patients were not coming in, or they were full with inpatient admission. And in either case, that had a significant impact on your DISH adjustment percentage, because if your beds are empty, then when you're looking at these different ratios, you're going to have much smaller numbers in terms of the percentage of your days that are made up of these low-income patients. And if you had your beds full of COVID patients, then the numbers might have been much higher than usual. And of course, you also may have had a different mix of patients in terms of payer coverage. And that, of course, matters because the ratios make up the DISH percentage are based on your preventive care, specifically to patients who have Medicare or Medicaid coverage and SSI coverage. And so if you have a lot of commercially insured patients, more than you usually do, you have more uninsured patients than you usually do, or if you have more Medicare or Medicaid patients than you usually do, that would all change those ratios and could have an impact on your overall DISH adjustment percentage. And so really early on in the pandemic, we started to have hospitals raise concerns to both HHS and to Congress that in light of these operational impacts from the pandemic, hospitals could be in danger of losing their 340B eligibility as a result of reduced DISH adjustment percentages. And so hospitals were seeking relief to prevent that from happening, to protect hospitals from losing eligibility. And sort of procedurally, the way that this relief really would be needed would depend on the timing of a hospital's filing of their Medicare cost report. As I'm sure you know, all hospitals in the Medicare program must file a cost report once a year. When that cost report is filed based on the hospital's fiscal year, and you only have 5 months after that cost reporting period ends before you file the cost report. So the concern was that we're in a pandemic now, and then once the next cost report is ready to be filed, the moment you file that cost report, if your DISH adjustment percentage on that new cost report is below the minimum threshold to participate in the program, the moment you file that cost report, you would need to terminate your program participation, stop purchasing drug at 340B pricing. And so the relief that hospitals were seeking from Congress was to avoid that from happening. And in fact, Congress did eventually provide some limited relief, some temporary relief to address this issue. Congress passed legislation earlier this year, March of 2022. So really 2 years into the pandemic. So at this point, there were already hospitals that may have lost eligibility, but certainly hospitals were also on the verge of losing eligibility as they were preparing to file new cost reports. And Section 121 of this Consolidated Appropriations Act of 2022 did address this eligibility issue. And it essentially provided protection for hospitals that already lost eligibility or were about to lose eligibility, but upon losing that eligibility, they would have the ability to be reinstated in the 340B program. But this relief is limited in nature in a few different ways. So in order to qualify for this protection, this reinstatement, the hospital would need to meet a few different conditions. First, they would need to have been terminated from 340B or lost eligibility for the program because they weren't able to meet that minimum dish adjustment percentage requirement for a specific cost reporting period. And a cost reporting period starting October 1, 2019, I think because that would have been the first cost reporting period impacted by the pandemic, which really began early 2020, and ending no later than December 31st, 2022. And we'll come back to that in a minute because that is a key condition that may limit how helpful this protection may be. Second, the hospital needs to have been terminated as a result of actions taken by or other impact on the hospital in response to or as a result of the COVID-19 pandemic. And then third, the hospital needs to have been participating in the program at the beginning of the pandemic. This protection is not help for a hospital that enrolled in 340B after the pandemic began. And I've included the link here to the website on HRSA's Office of Pharmacy Affairs because they do have information on their website for how hospitals can submit essentially an application to request reinstatement. The hospital believes it might qualify for this protection. So a few considerations to keep in mind if you think you're a hospital that is either has already lost eligibility or you're concerned that you're about to file a cost report and your dish adjustment percentage might be below the minimum threshold, and you're wondering, will this protection be helpful to us? So a few different considerations that I've put in three different kind of buckets here. First, whether or not you're eligible for this protection, for this reinstatement. As I mentioned, really the biggest, I think, tool that could be a barrier or a stumbling block is the fact that the reinstatement protection only applies for certain cost reporting periods. And there's a sort of a cutoff, and that cutoff I mentioned is coming up in the next month or so, and it is December 31st, 2022. In order to qualify for the protection, when you file a cost report and that cost report has a dish adjustment percentage that's below the minimum threshold, in order to avoid losing eligibility and to qualify for the protection, the cost reporting period that is covered by that cost report needs to have ended by December 31st of this year. So what does that mean practically speaking? Well, different hospitals have different fiscal years, different cost reporting periods, but I think that means that the last cost reporting period that could qualify for this protection would be one where, for example, if it's a calendar year, fiscal year, January 1 through December 31st, your cost reporting period ends the end of this year, you would file that cost report 5 months later, but in May of next year, that would be a cost report. I think the last cost reporting period could potentially qualify. A very common cost reporting period for hospitals is July 1 through June 30, if that's your fiscal year, and if your cost reporting period ended this past June 30th, you're about to file your cost report. 5 months later, you'd be filing your cost report by the end of November, so by the end of next month. So if you're about to file your next cost report and you're concerned that your dish adjustment percentage might be below the minimum threshold, then perhaps you might qualify for this protection, for this reinstatement. Another eligibility consideration is that our understanding of the scope of this protection is that it would apply not only if you're about to file a cost report and your dish adjustment percentage is low enough that you would lose eligibility altogether, then you could qualify to be reinstated so that you don't lose eligibility. But in addition, if you're a hospital that was participating at the dish hospital, but your dish adjustment percentage is falling below 11.5, but you're still above 8%, so you still qualify as a rural referral center or as a community hospital, this protection might help you so that you can stay as a dish hospital. So you could be reinstated as a dish hospital. So a couple of different ways that this protection could potentially be helpful. Second, some of the process considerations, really incredibly important. This is not just an automatic, you submit an application, HRSA approves you. You have to submit an attestation. You're signing a statement to the government attesting to several different statements. And one of the most important statements that you're attesting to is that you are able to provide explanation of how the COVID-19 public health emergency may have impacted your ability to qualify. So you do need to include a narrative with a justification for why you believe it was potentially because of COVID that caused your discharge percentage to fall below that minimum threshold. That's really important. I'll come back to the bullet and process in a moment, but I'm going to go over to our third bucket here, oversight. It is really important that you thought into that justification and feel comfortable saying that you believe that it may have been COVID that caused your adjustment percentage to fall below the minimum percentage, because there is going to be increased oversight of hospitals that take advantage of this protection. There's the potential for increased audit by HRSA, and we know that one of the government watchdog agencies, the Government Accountability Office, is looking into hospitals that have qualified for this protection, because Congress and the government really want to make sure that hospitals that would have lost eligibility even if the pandemic never happened, that they're not necessarily benefiting from this protection. So that is, I think, a really important consideration to make sure that as an organization, you feel comfortable submitting these attestations and qualifying for the protection in light of that increased oversight. I'll go back to process just for one last consideration to keep in mind. This has been somewhat of a rolling process. You may be a hospital that has already gone through this. You already filed a cost report since March earlier this year when Congress passed this legislation. You may already have submitted your attestation and already have been reinstated in the program, but you may need to reapply if you're getting ready to file a new cost report. And if again, verge adjustment percentage would be below the minimum threshold, and you think it may be because of COVID, you may need to submit an attestation again to continue receiving this reinstatement protection. On the other hand, if you're getting ready to file your next cost report and it's after that last deadline, if the next cost report that you're going to file is for a cost reporting period that ends after December 31st, then even if your adjustment percentage is below that minimum threshold, you may no longer qualify for the reinstatement protection, and at that point, you may lose eligibility. So a lot of considerations to keep in mind here. I would certainly recommend making this a very collaborative discussion within your organization. You know, if you're a pharmacy, if you're overseeing 340B, but thinking about whether this reconsideration or this reinstatement protection may apply, you would certainly want to be in touch with your finance folks, those who deal with your cost report files, to make sure you're on the same page in terms of the timing, when the next cost report is going to be filed, what the reasons were for why you think your adjustment percentage may have gone down, and also staying in touch with your legal counsel. I would certainly recommend working with counsel, especially with respect to the justification and these attestations, because you are signing statements and attesting to the accuracy of information that you are submitting to the government. And then lastly, I would note, certainly these developments are helpful if in fact you're at risk of losing eligibility because of the pandemic. But certainly a separate discussion if your adjustment percentage has gone down for reasons unrelated to the pandemic. There are certainly, different conversations to have in terms of potential ways to increase your adjustment percentage, looking at your inpatient services and your inpatient days and what the payer mix is, what the mix of patients is who are receiving care in the inpatient setting, thinking through ways to see if there are, in fact, ways to increase that adjustment percentage. But this opportunity is really specific to the impact of the pandemic on the adjustment percentage. Okay, so that was sort of our first development that I did want to address, because it really is a timely component to that, especially with hospitals that might be filing their next cost report later next month. Second, I want to really spend a few minutes talking about what is probably the issue that has been taking up the most of your time over the last couple of years, and it is these restrictions that drug manufacturers have implemented over the last few years that are affecting the ability of not just hospitals, but other types of covered entities to access 340B pricing, specifically for drugs that are dispensed through contract pharmacies. And before we talk about these restrictions, I do want to focus on kind of some background. And this may be a refresher for a lot of you if you kind of live and breathe 340B every day. But just to sort of clarify which setting we're focusing on here, because these restrictions that we're talking about do not apply in all settings where we might be using 340B drugs. When I think about 340B and the different ways that you might be using 340B drugs, billing insurance companies, receiving reimbursement for those drugs, and generating that 340B financial benefit, I think of three different settings, at least for hospitals, where you potentially might be using 340B. One, all hospitals have outpatient and mixed-use clinic areas. You'd be administering drugs in the emergency room and surgery areas, clinics. These are drugs that are billed by the hospital, not by the pharmacy, and certainly you can be using 340B drugs there. Second, not all hospitals have, but many hospitals do have their own in-house retail pharmacy. So this would be a pharmacy that's owned by the hospital. It's dispensing drugs billed by the pharmacy. There, you may be using 340B drugs as well. There's really not much from a process perspective to be able to do that. If the pharmacy is owned by the hospital, it's able to access 340B price drugs through the hospital as part of the hospital. But if, in fact, you also are thinking about dispensing 340B drugs to your patients through pharmacies that are not owned by the hospital, they are owned by a separate legal entity, then the hospital can enter into a contract with those pharmacies. They can serve as contract pharmacies and dispense 340B drugs on the hospital's behalf. It's through that third setting, through the contract pharmacy setting, where we're going to focus over the next few minutes talking about these policies that have been implemented by manufacturers restricting access to 340B products. So just a little bit more background, type of contract pharmacies. Really a couple of takeaways here that I just wanted to flag to put some of these restrictive policies in context. First is this distinction between the in-house or entity-owned pharmacy and the contract pharmacy. And as I mentioned, if the pharmacy is owned by the hospital, it's an entity-owned pharmacy. You can use the 340B drugs as part of the hospital. But the pharmacy is owned by a separate legal entity. The only way it could be dispensing 340B drugs on hospital's behalf is through this contractual arrangement, registering that arrangement with HRSA as a contract pharmacy arrangement. But the second kind of takeaway here that I wanted to flag is that there are a lot of different types of pharmacies that could serve as a contract pharmacy. And we certainly think very typically of chain pharmacies or independent pharmacies in the community, but this can also include mail order pharmacies, specialty pharmacies. Their brick and mortar operations may necessarily be in the hospital's community, but they're dispensing drugs and shipping them to patients' homes by mail. Then certainly patients within your community could be receiving drugs through those pharmacies that might be located far away from the hospital. And then lastly, what is not often thought of as a contract pharmacy, but could be, are pharmacies that are owned by a health system or some other subsidiary within the health system. This is not uncommon where there may be a pharmacy that's physically located in the hospital, but it's owned by a separate entity within the system. It's not actually owned by the hospital. And it might look like a hospital in-house pharmacy. Because it's owned by a separate legal entity, it would need to be registered as a contract pharmacy as well. So with that background in mind, what's the issue that we are facing with these restrictive policies? Well, let's first start with the government's position on the ability to have 340B drugs dispensed through a contract pharmacy. This is guidance issued by HRSA in 2010, although this position I think has been taken by HRSA since really the early years of the program. What HRSA has said is that even though the 340B statute itself does not actually mention contract pharmacy specifically, under the 340B statute, if a covered entity wants to have 340B drugs dispensed to patients through a contractual relationship with a pharmacy, the statute directs the manufacturer to sell that drug at no more than the 340B price to the covered entity. And of course, by extension, then the covered entity must still meet all the same compliance obligations under the 340B program with respect to 340 drugs dispensed through contract pharmacy. But the key takeaway here is that HRSA's position has been the 340B statute requires drug manufacturers to offer 340B drugs at discounted prices to covered entities, even when those drugs are going to be dispensed through a contract pharmacy. So, not surprisingly, manufacturers have taken a different position. And increasingly, at this point, we now have 18 drug manufacturers that have implemented some sort of policy that restricts access to 340B pricing for drugs dispensed through contract pharmacies. And the position that these manufacturers are taking is that they do not believe the statute requires them to offer 340B pricing to a covered entity if drug is going to be dispensed through a contract pharmacy. Some of these manufacturers are taking the position that they can meet their obligation under the statute so long as they offer 340B pricing to a covered entity for drugs to be dispensed through the covered entity's own pharmacy, and that alone can meet their obligation under the statute. There are different varying degrees of how restrictive these policies are and whether there are any exceptions to the policy. So a few different points to consider here when thinking about these 18 different policies. First of all, not all of them apply to all covered entities. They all apply to hospitals, but not all of them apply to non-hospital types. So 10 of these apply to hospitals only. The other 8 apply to other types of covered entities, but they all do apply to hospitals. Some of them do offer exceptions that are more meaningful than others. 6 of them do not really offer any meaningful exceptions, with the exception of an exception to the exception is that because they do take the position, these manufacturers, that they do need to at least offer 340B pricing to covered entities to be dispensed through their own in-house pharmacies. If you're a hospital that does not have its own in-house pharmacy, many of these manufacturers will say, in that situation, we'll let you have at least one. We'll let you have one external contract pharmacy relationship, but only one. And for some of these manufacturers, that's really the most meaningful exception that's offering. There are, however, 12 of these manufacturers that are offering what is a bit more of a meaningful exception, which is we will allow you to access 340 pricing for drugs dispensed through an unlimited number of contract pharmacies if you agree to share 340B claims data with the manufacturer. I'll talk in a few minutes about some concerns related to sharing 340B claims data. One other exception, I'll mention some, but not all of these manufacturers are offering, is that you may be able to continue accessing 340B pricing for drugs dispensed through a contract pharmacy without submitting claims data if there's a common ownership between the hospital and the pharmacy. And this can be a potentially helpful exception in those cases where you are with those hospitals as part of the health system and you have system-owned pharmacies or pharmacies that are owned by some other entity within the system that are acting as contract pharmacies. In that case, there may be an opportunity to qualify for one of those exceptions. So what is HRSA and the government doing in response to these restrictive policies? HRSA is actually really on the side of 340B covered entities here. They have taken the position, and they are bending that position pretty aggressively, that these manufacturers are in violation of the law, that the 340B statute requires them to offer 340B pricing for drugs dispensed through contract pharmacies, no exception, and that manufacturers are not allowed to impose any restrictive policies, restrictions on the ability to access 340B pricing in this manner. And so slowly HRSA is reaching out to each of these manufacturers as they review their policies, notifying them that they are in violation of the statute. They must immediately resume offering 340B pricing and issuing refunds. At this point, HRSA has sent these types of enforcement letters to 11 of the 18 manufacturers. And of those 11 manufacturers, HRSA has sent follow-up letters to 8 of them, letting them know that time has passed, they have continued to violate the statute, they have not resumed offering 340B pricing, and as a result, HRSA has referred those manufacturers to the HHS Office of the Inspector General for the OIG to consider whether to impose civil monetary penalties against those manufacturers. That is an authority that HHS has under the 340B statute. If a manufacturer has been overcharges a 340B entity, then HHS may impose the penalty against the manufacturer for to penalize the manufacturer for committing overcharge. Well, how are manufacturers responding to HRSA's enforcement? Not surprisingly, they are challenging those enforcement actions. A number of drug manufacturers have filed lawsuits in federal court, pushing back on the enforcement letters, saying that they are illegal, they are not allowed under the 340 statute. And what's really going on here is a debate over the government's interpretation of the 340 statute. We have two competing interpretations of the statute. HRSA, on one hand, is saying that our interpretation of the 340 statute is that there are exceptions allowed, manufacturers must offer 340 pricing, they may not impose unilateral restriction. And that HRSA says that is not only a reasonable interpretation of the statute, but the most reasonable interpretation of the statute. Manufacturers, on the other hand, that is not a reasonable interpretation of the statute. They think their interpretation is the more reasonable one, which is there's nothing in the statute that requires manufacturers to make 340B pricing available through an unlimited number of contract pharmacies. At this point, we have had 4 different decisions at the lower court level in federal districts. Those 4 decisions are all on appeal in 3 different circuit courts, 3 different appeals courts. And we just had oral arguments in one of those 3 cases earlier this week. And we have oral arguments scheduled in other cases really over the next few weeks, later this month into November. And they're mixed decisions. Of the 4 decisions that we've seen so far, 2 have been more in favor of HRSA and providers, and 2 have been more in favor of manufacturers. So here, these are the 2 decisions that were more in favor of HRSA and providers. And here, the courts found that HRSA's position was reasonable, and that it was a reasonable take on the 340B statute to say that manufacturers are required to offer 340B pricing for drugs dispensed through contract pharmacies. A little bit of a mixed decision, though, in both cases, because even though the courts upheld the interpretation, they still found that there were issues with the enforcement letters that HRSA sent. One case because HRSA's position on contract pharmacies has changed over the years, and in the other case, because it was not clear whether an unlimited number of contract pharmacies are required and whether civil monetary penalties are warranted. But in both cases, acknowledgement that HRSA's position is a reasonable one. The other 2 decisions were certainly more in favor of manufacturers. In one case, the court found that the manufacturer's policies were not in violation of statute and really took issue with the fact that HRSA's position is that the statute does not allow any type of restriction. The court found that that was really overly broad, and that there may be certain restrictions that are prohibited and there may be certain restrictions that are allowed. Now, that court did not actually win on the manufacturer policy in question, evaluate whether those specific restrictions were allowed. And in fact, the oral arguments that were just held in this case, the circuit court judges, at least 2 of them, really kind of took a similar focus, which is we're not sure that the statute prohibits all restrictions, but we also don't know whether these particular restrictions are allowed. So that's really an open question. And then this 4th decision was probably the one that was most squarely in favor of drug manufacturers, finding very clearly that the statute is unambiguous. Manufacturers are not required to offer 340B pricing for an unlimited number of contract pharmacies. So where does that leave hospitals? As I mentioned, one of the more meaningful exceptions to these restrictive policies is that at least for I believe those 12 of 15 manufacturers, hospitals and other covered entities may still continue to access 340B pricing for drugs dispensed through contract pharmacies if they upload the claims data for 340B claims and share the claims data through an online platform that would then be shared with drug manufacturers. And so hospitals are really thinking through whether that is something they want to do. And, I've kind of put into 3 different buckets some of the potential concerns or considerations related to whether a hospital would want to share that claims data or not. 340B compliance considerations, there's nothing in the 340B statute that requires hospitals to share this data. And really, the reasons why manufacturers are requesting that data are not really tied to 340B compliant obligations either. Use of data is sort of a second consideration. One of the real key concerns from a provider perspective is that if providers share claims data with manufacturers and then they share that claims data with payers, payers will then have access to which claims are for 340B drugs, and will that result in lower reimbursement rates from payers for 340B drugs? And the third category, which is the one that probably raises the most legal considerations, and this is certainly one where I think hospitals should work with legal counsel to think through the various issues at hand, have to do with HIPAA and data privacy, because there is this personal health information, PHI, that is implicated here that could be uploaded, although it's supposed to be stripped out of the system. Questions about whether that's being done appropriately, questions about the hospital's obligations that HIPAA covered entities, questions about terms of use associated with online data sharing platforms. Those are kinds of legal agreements that are typically reviewed by counsel. So, these are really the types of questions that I think hospitals are thinking through as they're trying to evaluate, do I want to try to take advantage of this exception or not? And lastly, in terms of next steps, certainly the courts are going to be continuing to consider the legality of these manufacturer restrictions, consider the legality of HRSA's mission, and whether or not HRSA can in fact impose these penalties against manufacturers. Congress has also been involved in this discussion to some extent. Congress, has two different roles that they can play, two different sets of tools that they can use. They can certainly pass legislation, but they can also conduct oversight. Congress passes laws, they direct agencies to implement those laws. And so Congress can conduct oversight, make sure that the agencies are implementing those laws properly. So far, over the last couple of years, Congress has been very involved in the oversight side of it, but not in legislation. And so there's been really strong bipartisan support from members of Congress in both House and the Senate in support of 340B providers, sending letters and urging HHS to use its authority to penalize manufacturers that are violating the statute, to really enforce the 340 statute, to stop these restrictive policies from moving forward. The next question is whether Congress will intervene from a legislative perspective and try to pass legislation to make it clear that manufacturers must offer 340B pricing in the contract pharmacy setting without condition. That's, I think, something to keep in mind as we look into the next Congress, look into next year. Okay, the next topic that we'll quickly touch upon are developments related to HRSA audits. And I do want to kind of with a specific focus on the definition of a 340B eligible patient and findings that we're seeing for diversion. Diversion is giving a 340B drug to an individual who is not a patient of the covered entity. The reason why we're talking about recent developments related to HRSA audit is because public statements HRSA has made about the types of audit findings that they issue. HRSA has been conducting audits of covered entities since 2012. Now, the program began in 1992. We did not see the first audit in 2012, so it took some time for HRSA to put that process in place. Between 2012 and 2019, HRSA really ramped up its audit enforcement, getting to a point where HRSA began auditing 200 covered entities each year. And we really started to see a significant number of diversion findings that covered entities were using 340B drugs for individuals who are not eligible patients. And HRSA over the years issued guidance on their understanding of what is a 340B eligible patient, because the statute itself does not define what is a patient. The statute says that covered entities may not transfer or resell 340B drugs to individuals who are patients, but does not elaborate on what is patient. So HRSA was issuing audit findings between 2012 and 2019, based on its position or its interpretation of what is a 340B eligible patient. In 2019, HRSA told the GAO, the Government Accountability Office, that it conducted a review of its audit enforcement. And this review is triggered because of a lawsuit that a covered entity filed against HRSA, which we'll talk about in a moment. But as a result of this review, HRSA came to the conclusion that, quote, in the absence of binding and enforceable regulations, the agency would no longer issue audit findings based solely on non-compliance with guidance. And HRSA went on to say, quote, they will only issue findings when audit information presents a clear and direct violation of the requirements outlined in the statute. So what does this mean? What this is getting at, and specifically in the context of patient eligibility, because HRSA did tell the GAO that they're acknowledging that the 340B statute does not provide criteria for determining patient eligibility. And so what HRSA seems to be saying here, as reported by the GAO, is that we're still going to issue diversion findings in a situation where it is clear based on the information we collect in the audit that you gave a drug to an individual who's not a patient. But if there is a situation where you use 340B in a way that may not exactly be consistent with the guidance HRSA has issued over the years, may not be consistent with HRSA's interpretation of what is a 340B eligible patient, but it's not clear whether that use of 340B was really inconsistent with the statute, and they may not issue a finding. Now, that doesn't tell us that much. It seems to suggest there are situations where previously HRSA was issuing diversion findings, but now, as a result of this change in audit authority, HRSA will no longer be issuing audit findings. But it doesn't give us much of a sense of what the line is. When will HRSA issue a diversion finding? When will HRSA not issue a diversion finding? The focus, I think, that we've really been seeing on what that line is and what HRSA's focus is has to do with the location where a prescription is written. And this comes into play in that lawsuit that I mentioned brought by a covered entity against HRSA, challenging a diversion finding in an audit. And in this case, the covered entity took position that the statute only limits the covered entity's ability to use 340B drugs to individuals who are not patients, but it doesn't speak at all to the location where a prescription was written. So as long as the individual has received services from the entity and is a patient of the entity, then you should be able to use 340B drugs for any prescription written for that individual. And that was a much broader position than the one put forward by HRSA in the diversion finding audit report, because HRSA took the position in that audit report that there was diversion because covered entity used 340B to fill a prescription that was written outside the covered entity by a non-covered entity provider. And so the location where the prescription was written and whether it needs to be written at a covered entity really was the core of this dispute. HRSA ultimately withdrew this diversion finding. So with the audit report was voided. And as a result of that, the fact HRSA withdrew the audit finding, the district court dismissed the case. They said there's nothing left for the covered entity to dispute because there's no longer an audit finding. So kind of course, the case was dismissed on procedural grounds. Well, on appeal to the Fourth Circuit, the appeals court reversed the lower court's decision, disagreed, and said should not have dismissed this case because there's still a live controversy here. There's still a question that needs to be addressed by the court, and that is whether HRSA's interpretation of what is a 340B eligible patient is allowed or not. And so the appeals court has remanded the case back down to the district court, and so the district court is actively considering this case now, which should decision perhaps sometime next year, on whether or not the court agrees with HRSA's position on what is a 340B eligible patient. Unclear how much clarity ultimately that decision will provide us, but we'll have to monitor that decision to see what implications it might have for HRSA's audit moving forward. And so where does that leave us today in terms of our observations on current audit enforcement? Well, what we do know is that even though HRSA has acknowledged that there has been a shift in audit enforcement, there continue to be diversion findings. HRSA is still issuing diversion findings. And there appears to be a specific focus in these findings, at least the way that the language that HRSA is using when it publishes its findings on its website. There's a focus on the use of a medical record. So we're specifically seeing findings where 340B drugs were dispensed at contract pharmacies, but not supported by a medical record. Now, HRSA hasn't told us what they're looking for in the medical record in order to support 340B's but that is a finding we continue to see. We also, not surprisingly, continue to see findings when 340B drugs are dispensed to inpatients. I think that's one where the agency is saying this is clear, that is a violation of statute. And we're also still seeing findings for 340B drugs prescribed by ineligible providers, which can sort of get at the location issue in terms of if it's written off-site by a provider who's not the covered entity's provider, it's a non-covered entity location, but perhaps they're focused more on the provider and not necessarily on the location. So this is another area, certainly working with legal counsel is important because this is a changing space. And I think there's a lot that entities can think about in terms of statements made by HRSA, shifts in audit enforcement, trends we're seeing in the findings, thinking through what that might mean for your policies and procedures and your use of 340B moving forward, but also continuing to monitor this litigation because there could have significant implications for what we see in audit enforcement moving forward. So lastly, this is the last area in terms of recent program developments that I wanted to flag during our discussion today, and it has to do with Medicare payments to hospitals for 340B drugs. And this has actually been a positive development because we saw a Supreme Court decision earlier this year squarely in favor of 340B hospitals. And the decision had to do with a policy first implemented in 2018, where Medicare decided to pay 340B hospitals under the Outpatient Prospective Payment System, the OPPS system, paying for 340B drugs to hospitals under the OPPS at significantly lower rates than those paid to non-340B hospitals. This payment policy did not apply to critical access hospitals, so I just want to flag that. But the issue was whether or not Medicare was authorized to implement this particular policy. And the court ruled that Medicare was not, that this particular payment policy was not consistent with the authority granted to CMS under the Medicaid statute. And so the ultimate finding was that payment rates that issued here, and they were specifically focused on payment rates in 2018 and 2019, were unlawful. So I want to unpack this decision a little bit more, and we'll talk about next steps in terms of what we expect to see for the remainder of 2022, and also what we might expect to see next year and moving forward. Just a little bit of a refresher on the payment policy. Prior to 2018, under the OPPS, 340B hospitals were paid by Medicare for these high-cost, separately paid drugs, the same rate that Medicare used to pay on 340B hospitals, which was the average sales price, ASP, plus 6%. Starting in 2018, for the first time, Medicare changed this policy and began reducing payment rates for 340B drugs by close to 30%. Instead of paying ASP plus 6%, Medicare began paying 340B hospitals for their drugs at ASP minus 22.5%. And in addition, Medicare also created a new modifier requirement, requiring hospitals paid under OPPS to attach a modifier when they bill Medicare for a 340B drug claim. And they created two different types of modifiers. The JG modifier, which triggered the reimbursement reduction in situations where the 340 drug was subject to a payment cut. And TB, which was an informational modifier, and then used for hospitals not subject to the payment cut, but also in cases where a hospital is subject to the payment cut, but they may have used a 340B drug that was excluded from the payment reduction. So as I said, critical access hospitals not paid under the OPPS, not subject to these policies. Rural sole community hospitals and freestanding children's and cancer hospitals paid under the OPPS were exempted. So they were not subject to the payment cut, but they were still subject to the informational modifier requirement. Maryland hospitals, because they're paid under a waiver, not subject to these rules either. Medicare applied this payment reduction in a budget neutral manner, which means that when the payment goes on for one service, payment needs to go up for another service. So on the whole, it didn't save Medicare any money, but it did reduce payment for 340B drugs in the first year by $1.6 billion, which meant that it increased payment for non-drug services to all hospitals paid under OPPS by an increase of $1.6 billion. There were some slight changes and expansions to the policy in 2018, but in large part, this policy remains the same from 2019 through 2022 was when this case was brought before the Supreme Court. So the question before the court was whether or not Medicare has the authority to reduce payment to 340 hospitals, specifically without doing a survey. And the reason why there was a focus on a survey is because under the Medicare statute, Medicare has authority to pay for these high-cost specialty drugs, separately paid drugs, under one of two different ways. If there is a survey done that collects information on hospital acquisition costs, then CMS can pay for drugs based on average acquisition costs, and they're allowed to vary that reimbursement by hospital group. So different hospital groups could pay at a different rate. But there needs to be a survey to support those average acquisition cost payment rates. Or if the data is not available, then CMS can pay based on the average price for the drug, which is essentially using the standard default reimbursement rate of ASP plus 6%. And that can be calculated and adjusted as necessary by the Secretary. So when CMS first implemented this policy, there was no survey data. They admitted they had not conducted a survey and said they were relying on their authority under that second option. And they said that they have to pay based on the ASP plus 6% methodology, but they argued that they were allowed to adjust that reimbursement downward to ASP minus 22.5%. That was the question before the courts, whether CMS was justified in reducing reimbursement, paying 340B hospitals at a different rate than non-340B hospitals under that second option where there was no survey. And as I said, CMS argued they're allowed to do this because they have the authority to adjust rates downward. But CMS focused on the fact that there was no survey, and they focused on the fact that in the situation where there is a survey, you're allowed to vary reimbursement by hospital group, but there is no survey, there is no authority to pay different rates to different groups of hospitals. And so because there was no survey, CMS was not allowed to pay 340B hospitals a different rate than non-340B hospitals, and that was the rationale for why this PIM policy was unlawful. Now, importantly, the court did not address the issue of remedy, so they remanded the case back down to the lower court to figure out what the next steps are. So what are next steps? Well, we did get a response from CMS. They issue a new proposed rule and minor rule every year outlining what the payment rates are going to be for the next year. And so we saw CMS issue its proposed rule for the 2023 OPPS rates. This proposed rule was issued past summer. And at that time, the Supreme Court decision had just come out. So technically, they proposed to continue the 340 payment reduction, but they said the only reason why they were including that proposal because they didn't really have time to update the proposal to reflect the court's decision. But in light of the court's decision, it was CMS's intent to end the 340B payment reduction, and that next year, 2023, CMS intended to pay 340B hospitals at ASP plus 6%. But they also solicited feedback on what to do for remedies for prior years, how to address this going backwards. And they also suggested the possibility that in future years, they may still be able to reduce reimbursement rates to 340B hospitals. And this is in recognition of the fact that the court acknowledged that if there is a survey of acquisition costs that supports a lower reimbursement rate to 340B hospitals, and if CMS bases its rate on that survey data, then it could have a separate and lower reimbursement rate just for 340 hospitals. So that's something that CMS sort of flagged the possibility of in this proposed rule. And we're waiting for the final rule to be issued sometime in November. So what's next? Well, as I mentioned, the Supreme Court remanded the case back down to the lower court, and the district court has been considering what to do next. They did first ask both HHS and the hospitals what they think the remedy be. CMS said, we think you should remand this to us so we can figure out what the remedy should be. Oh, and by the way, CMS also says, we think the remedy needs to be done in a budget neutral manner, which means if we pay anything back to 340B hospitals, we may have to take something back from non-340B hospitals. And meanwhile, hospitals have said, we think the court, you should mandate what remedy should be. We think it should go all the way back to 2018. We want a lump sum payment to pay us back the thing that we should have gotten had we been paid at the full rate of ASP plus 6%. And we think that it needs to be done in a budget neutral manner. You don't have to take any money back from non-340B hospitals. In late September, we did see a decision from the federal district court in the District of Columbia, vacating the 2022 payment rates, ordering HHS to resume paying 340B hospitals at the same rate as non-340B hospitals immediately. So essentially, the court said, you can't wait until 2023. You need to do this now. And so CMS did respond in mid-October, issuing guidance that said they will start paying 340B hospitals at ASP plus 6% for the remainder of the year. And they would also reprocess 340B claims already paid on or after the date of the court's decision in September. Now, we have seen that some of the Medicare administrative contractors, the MACs, have posted statements to their website saying that they might adjust and repay hospitals to adjust those claims that had already been paid going back to the beginning of 2022 and re-adjudicate them based on the ASP plus 6% payment. So that's something different MACs have said different things we need to sort of keep an eye out for, but there may be an opportunity to be made whole for all 2020 claims. But we do not yet have any indication as to whether and what remedy there may be going back to 2018. That's still an open question. Also, neither the court nor CMS have addressed what hospitals should be doing with respect to the modifiers, even though the 2022 payment reduction has been declared unlawful. The court did not address the modifiers in terms of whether hospitals should still be using those modifiers, even if they're only for informational purposes. And there still continue to be these questions about budget neutrality and its role play in any remedy, and also the use of survey data, whether her HHS, CMS, and the board may try to either base future payment rates on survey data, or whether they may try to rely on survey data to say we don't need to repay hospitals for prior years because the survey data might support a lower reimbursement rate. So certainly still a number of unanswered questions, but you know, hopefully we can end here today on a positive note, focusing on this really positive Supreme Court decision that was in favor of hospitals, very positive district court decision, follow up to that Supreme Court case in favor of hospitals. There should be some repayments going back to hospitals, at least for 2022. And the next step will be what CMS finalizes for payment rates next year and what the next steps will be for any potential remedies in prior years going back to 2018. So with that, I think that brings us through the 4 areas that I want to focus on today. Certainly other areas going on in 340B that we could be talking about, but those are the ones that I think I'm talking about the most with clients. I'm hearing about those. My contact information is here. Please feel free to reach out if you have any questions. I'd be happy to connect and see if I can be helpful. Thank you so much for having me today. And I'm going to turn things back to Jody to close us out today.
Thank you so much, Jeff. That was a wonderful presentation and very, very informative. And I want to thank all of our members who have tuned in for the 340B Hospital Updates webinar. If you have any questions about today's presentation or about 340B solutions, please reach out to your Strategic Partners representatives. And I want to say again, thank you so much, Jeff, and for everyone to have a wonderful day.